Hey, folks, how's it going? I'm super excited about today's conversation. Yesterday, the United States Supreme Court issued an opinion regarding free speech. And basically, we have a guy who was convicted in the state of Colorado for stalking a woman online and sending her the most disturbing amount of messages you could imagine. And she blocked him. So he'd get a new profile. She blocked that. Then he'd get a new profile and she'd block that. She kept having to block him. And he kept going after her and going after her. And the messages would get like worse and worse. You know, sometimes it was okay, kind of like, I am going to the store. Can I pick you up anything? How come you've never asked me that, Mateo? I can't, after everything I've done, you know. Was that you in the white Jeep? You know, 5 years on Facebook, only a couple physical sightings. These are just some of the examples. Seems like I'm being talked about more than I'm being talked to. This isn't healthy. I've had tapped phone lines before. What do you fear? It's kind of weird. And then some sort of weird text, stylized text. I'm currently unsupervised. I know it freaks me out too, but the possibilities are endless. Had like liquor bottle images, a guy's version of edible arrangements. How can I take your interest in me seriously if you keep going back to my rejected existence? And then it would progressively get worse. Fuck off permanently. Your arrogance offends anyone in my position. You're not being good for human relations. Die. Don't need you, you know? And it just, like I said, it gets, you know, talking to others about me isn't profile sustaining for my benefit. Let's see. I can't read all of these because I'd be here all day. I mean, he sent thousands of these things, right? And like I said, he kept blocking, or she kept blocking him, and he would do new profiles and everything, which that right there is crazy. That should be illegal, like contacting someone from a fake profile, or, you know what I'm saying? So anyway, so he got arrested and served time in prison, and you know, he appealed it. It ultimately went to the Supreme Court. And then the Supreme Court of the United States reversed the decision and said that what he was doing was protected by free speech. All right. Now that's the short version, and it's very, you know, now comes the part where I explain it. Okay. All right. So here we go. So you know, I don't want to say she was a singer. I mean, not like super popular singer, but I don't want to say her name, you know, just out of respect. I feel so bad for what happened, you know. So anyway, she was a singer in Colorado, and she had concerts and everything, and that's probably where he first saw her. And it was so bad that she stopped walking alone, like anywhere she'd go in public. She would do things like, you know, she has trouble sleeping. Anytime she was in public, she would be fearful. She was starting to do some concert where like a few hundred people would go. Then she canceled all those, you know? So it was, you know, like I said, it was very, very bad, what happened to her. So that's why a lot of people are very concerned about the United States Supreme Court decision saying that the state of Colorado wrongfully convicted him, and that the statute that they had was unconstitutional, you know, and in violation of the First Amendment. Okay, so here we go. He was starting to do this in the year 2014, all the way to 2016 when he finally got arrested. So for those couple of years, you know, like I said, he was typing out all these messages, sending it to her nonstop. And because she wanted to be a singer, she wanted to have you have to have a social media account, right? So she had a social media account, and she wants to be a singer. She has a social media account, and this guy, you know, kept doing what he was doing. Because some people would say, well, why does she have to have a social media account? You know, I mean, it's just part of business, right? You have to have a telephone, or you could have a telephone number. Like, people have things, right? And so the onus is not necessarily like, once you get a Facebook account, you open yourself up to this. There's no rule that says that. You still should be protected, right? So he was arrested in 2016, and then he was charged with stalking her. And then this is where, he first makes the position that the way the statute in Colorado reads is this. The state charge, his name is Billy Counterman. It's kind of a, I wonder if that's a counterman. Where is that word? Okay. Under a Colorado statute making it unlawful to, here's the statute that he was charged with. Repeatedly make any form of communication with another person in a manner that would cause a reasonable person to suffer serious emotional distress and does cause that person to suffer serious emotional distress. So there you go. That's the statute. So you can't, in Colorado and in every state, basically, you can't keep contacting somebody and in a way that would cause a reasonable person to get freaked out. And so you can't do that. They say something funny. It's like that would cause a reasonable person to get freaked out and in fact does freak out this person. So for example, if a reasonable person would get freaked out, but let's say Joe Samo doesn't get freaked out, like a reasonable person would get freaked out, but I didn't, then, it wouldn't be a violation because there was no harm, If it's something where you send something nice to somebody, like one message saying, oh, that was a great concert, and that was it, and the person gets freaked out, then it's like a reasonable person would not have been freaked out. So you have to have those two things to be convicted under this Colorado statute. And it's a big deal because he ends up spending 4 years in prison. Give or take a few months. So he spends 4 years in prison after he was arrested in 2016. His argument in the Colorado case, the trial court case. And by the way, what is a reasonable person and what is emotional distress, this and that, it's up to a jury to decide. And indeed, a jury convicted this guy. So a jury held beyond a reasonable doubt that what he was doing would cause a reasonable person to, suffer severe, what's the right terminology here? That a reasonable person would suffer serious emotional distress, right? So a jury made that ruling, and so it wasn't like he was convicted in front of a jury. His position, believe it or not, in the state of Colorado, he made an argument through his lawyers that, well, this is unconstitutional because the standard should not be if somebody gets serious emotional distress. It should be if somebody does get serious emotional distress and the person intended the other party to have serious emotional distress. And so what he was saying is, well, I didn't intend, or Colorado's not proving, because it's not in the statute, they're not arguing, or they're not proving, they don't have to prove an element to put me in prison, that I intended to cause serious emotional distress. So the Colorado trial court said no. The statute is fine. It would be impossible almost for us to prove, that what your subjective intentions are, right? So that would be such a high element that people could be stalking and saying anything they want. And then what are we going to do? We don't know. It's going to be hard for us to prove subjectively that you intended this person to have all this serious emotional distress. He appeals that to the Colorado. He appeals it to the Colorado appellate courts. Eventually, after like a kind of circuit of appeals type of thing, the Colorado appellate court agrees with the Colorado trial court judge. So it took a while to go from the trial court judge in Colorado to the, to ultimately exhausting the appeals in the state of Colorado. And then ultimately all the appellate judges in the state of Colorado that were on this case said, indeed, what the statute is not unconstitutional and it's not a violation of free speech. We don't have to prove that somebody like subjectively in his own mind thought that he was going to cause this harm. So there you have it. So he has one last shot to appeal this. and he appeals it to the United States Supreme Court. And then the United States Supreme Court takes this case. And by that, I mean, the United States Supreme Court does not take all the cases that people appeal to the United States Supreme Court. In fact, it's a very small percentage, and there's even a requirement that enough judges want to take the case for the case to be heard. It's called being heard in the United States Supreme Court. Now, and especially if any of you are interested in law, you want to go to law school, this is some serious jurisprudence here about how they go through this in the United States Supreme Court when they reverse this guy's conviction. The United States Supreme Court held that to convict somebody of making threats and stalking, the state or federal government must prove that that person subjectively intended to cause harm, and that the element has to be, there's he accidentally caused harm. No, that won't work. He was negligent in doing this. That won't work. They have to prove he was so reckless in what he was doing that he subjectively wanted to disregard her mental state and cause her harm. All right. You see what I'm saying? That's a tough standard, right? And so the guy gets, his conviction gets overturned. Now, a couple of things that drives me nuts. And I just want to get it out of the way. The Supreme Court. It's kind of funny because there's all these laws that protect judges from being intimidated or threatened. For example, there's a federal law that says, this is the United States Code, whoever corruptly or by threats of force or by any threatening letter or communication endeavors to influence, intimidate, or impede any judge, blah, 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 is, could go to prison. And I think, if I'm not reading it wrong, for not more than 20 years. Okay. And so you can't, if this guy was doing any of this to a judge, especially to a Supreme Court judge, he'd be arrested. And the United States Supreme Court never held, there's no element in here that they have to prove the guy secretly was doing this. Okay. There's also another federal law that was not held unconstitutional. You can't even picket or parade meaning you're walking down, by a Supreme Court justice's house. Whoever with the intent of interfering with, obstructing, or impeding the administration of justice with the intent of influencing any judge in the discharge of his duties, or uses soundtrack, okay, shall be, subject to prison term, okay? So that's kind of, I don't like that. In fact, the Supreme Court judges, they don't even allow people to go in and videotape, because it's oh, no, we don't want any sort of influence here. And same with federal judges. They don't even allow people to go to the courtroom and videotape. They just get nervous. Oh, that might be intimidating us or whatnot, okay? So back to this case, what's the rationale, and then how, is cyber stalking now allowed, right? Did the Supreme Court basically just open the floodgates to allow cyber stalking? All right. So we have here the Supreme Court. Now what they're saying is that they don't want, there's this thing in law, they always say about, especially with the free speech, that is because bans on speech. Okay, sorry, let me start that over. Pause. Okay. That is because bans on speech have the potential to chill or deter speech outside their boundaries. So what they're saying is anytime you don't allow a certain speech, then the scare is that it's going to chill other people's speech, or deter other people's speech. And then they're saying true threats are serious expressions conveying that a speaker means to commit an act of unlawful violence. So here we go. So the court is saying that there has to, the state has to prove that like I said, the person is intending to do this. Okay. A speaker's fear of mistaking whether a statement is a threat, fear of the legal system getting that judgment wrong, and fear of incurring legal costs may lead a speaker to swallow words that are in fact not true threats. Insistence on a subjective element in unprotected speech cast, no doubt, has a cost. All right. So what they're saying here is they don't want like a speaker, meaning somebody that wants to make the speech, or like in this case, this counterman jerk. They don't want these people to fear that, oh my God, I'm trying to be nice. I'm trying to help this singer. I'm trying to just flirt with her, damn it. And I'm not going to do that because, oh, she's going to interpret it as stalking, right? So the United States Supreme Court says, no, that would not be proper to go after him for that. I think that's a little crazy. And then the United States Supreme Court is then saying that the state has to prove this thing about the recklessness, that the person either subjectively and actually wanted to hurt her, or he recklessly disregarded all the laws and all of customs and everything, and that he was so reckless that he just wanted to hurt her. Okay, kind of, it's almost the same thing as him wanting to hurt her. You know. All right, and this was written. The opinion was written by Kagan and joined by 6 other judges. There were 2 judges who dissented to this opinion, meaning they did not agree with the majority, and that was Justice Thomas and Justice Barrett. Now, what the heck does that mean? That means 2 of the 9 judges thought that the Supreme Court got this wrong. But now, I mean, this is the law. So I always have this joke. I'm like, so what? Did they fail constitutional law? Right? Did those 2 dissenting judges fail constitutional law? And worse, how did all of the judges in the state of Colorado get this wrong? And when I've had so many cases where my client got a restraining order just based on like certain things that he would say or she would say. And now what? Because of this case, I think I could go back and sue the state saying that, well, that was improperly granted. I'm not going to do that, but I'm saying I could because of this case. All right. The First Amendment still requires proof that the defendant had some subjective understanding of the threatening nature. And then the court says the same applies to obscenity laws, defamation laws, and like incitement of riots. So what the court is saying here goes like this. With obscenity laws, there are some laws that say, like you can't like have, strip clubs, whatever, by a school, or you can't sell dirty magazines, or something, or you can't send, whatever. There's anti-pornography laws, right? And so, but the question is like, what's pornography in some cases, right? So they've long held that, well, to punish somebody, the state has to prove this kind of same standard, that the person intended to be obscene, that the person intended to kind of shock the others, so that in the free speech realm with obscenity laws, it's the same thing, that the state always has to prove the subjective element. Same with defamation, the court says, which is true that the court has held. Like if you want to, if somebody says, oh, Donald Trump's a jerk, or says something about Donald Trump or about President Biden, any sort of public figure, for the public figure to win in a defamation case, they have to prove that the person intended to be a liar or that they were so freaking reckless that they basically intended to be a liar, right? So those standards apply there. The court says. And there was a famous case in Ohio where there was like these Ku Klux Klan members who are having a protest, and then one of the speakers was saying, this is BS, this isn't proper, where the races are mixing and blah blah blah. That was Brandenburg versus Ohio. He got arrested, and then ultimately he won because the United States Supreme Court said, well, we the exact wording. Insightful, violent speech is a hairbreadth away from political advocacy. So if we, say to this KKK dude, you can't speak, right? Because you're going to incite violence. Like the threshold has to be so high, and you have to prove that he intended for some sort of riot to start right then and there, right? And otherwise, we cannot punish that because of this that political what is it? What's it again? I have to like say this very carefully because I don't want to say it wrong. The incitement of violence is a hairbreadth away from political advocacy. That's not my words. That's the United States Supreme Court. Okay, and now they're applying those kind of standards to this case. So what actually has to end up happening now is this. For the state of Colorado and for any state moving forward after this, any sort of like online stalking or telephone stalking or whatnot, they this is going to be difficult because they have to get a jury to agree beyond a reasonable doubt that that person intended to do this. And that's going to be hard because the Fifth Amendment says that if the person doesn't want to testify, he doesn't have to. So how in the world is the prosecutor going to get a jury to agree unanimously that this person's subjective thoughts were, such when the person doesn't even have to testify, right? Believe it or not, it is a standard in a lot of law. Like a murder case, it's called like you have to, the difference between an intentional murder and an accidental murder. Like you're driving fast and you accidentally run someone over, where as opposed to like just intentionally killing somebody. It's pretty clear if someone takes a gun and goes somewhere and starts shooting that he intended to kill people, right? Even if that person doesn't testify. So it's not impossible to get a jury to say, okay, this was the subjective thought that the person had, right? So so in those cases, in law we call it mens rea. It's an old Latin term. So it's not impossible to get it. And in fact, the state of Colorado here, if they want to keep this conviction good, and they better because he may be entitled to millions of dollars of damages because he spent 4 years in prison unconstitutionally being held. You see what I'm saying? That's a big deal, right? And so anyway, they have to go back. The procedure in this case is that they send it back to the trial court. Now, if the trial court and the prosecutor still want to get a conviction, he's not innocent, but they would then have to redo the trial with a, instead of telling the jury the instruction that they did tell the jury in the first trial in 2016 or 2017, they asked the jury, do you think his actions would cause a reasonable person to have serious emotional distress? They said yes. Instead of asking that, they have to now ask, did he intend to cause serious emotional distress, and then they also have to ask, and was it reasonable that somebody was then emotionally distressed about this? So it's just a much, much higher standard. And I am not happy. Okay. I do agree here with the dissenting judges. Okay. So Justice Thomas, he dissented, meaning he disagreed. His position in his dissent was that we should not have this subjective element. He said that it is the United States Supreme. It's kind of weird. He actually agrees. Okay, get this. Here it is. There's some jurisprudence law here. Okay, he agrees with the majority, but he thinks that the Supreme Court should reverse or overrule previous law. Okay, let me explain that. He says that, okay, fine. The standard in a lot of cases is the subjective element, but that is not what the framers of the Constitution intended. So we should reverse New York Times versus Sullivan. This is an older case, 1960s case in the Supreme Court. He said we should just do away with that. And instead of having to prove this subjective element, we should just make new law. Or actually, he's not saying make new law. He's just saying the Supreme Court has improperly interpreted the framers of the Constitution, right? So he's saying to make up for that, we should just overturn that case, that New York Times versus Sullivan, and we should just have the standard be what the Colorado state said, which is if somebody does something that's clearly, hurting somebody else and that a reasonable person would have been hurt by what the dude did. It doesn't matter what he subjectively intended. That's a violation. All right. Who wants to study constitutional law? This is what goes on in constitutional law. I had these legal cases with another lawyer here in San Diego, and that lawyer got disbarred. And I've always thought it was unfair why he got disbarred. What happened was he had a case in front of a judge here in San Diego, and it was in front of Judge Taylor. So he had a case in front of Judge Taylor and had something to do. This was back in the day, right? This is like 15 years ago. Something with those pedicabs, like something about some guy that got either cited or arrested or something for driving a pedicab, the bicycle cab thing, without a license, or he overdid it, whatever, right? And so this guy, the disbarred lawyer, he lost the case, and he was so upset that at the judge, he wrote the judge a letter and then sent it to the judge's house, right? Judge Taylor, you got this wrong. The law is this, and you improperly applied it. Oh, it was a nice professional letter. Oh, I'm sorry, Judge. He got so scared, he called the state bar. Right? There was no threat. He was just saying this is so improper and, this and that, right? Then it gets better. It gets way better. Ultimately, this guy appeals that judge's decision, and then guess what? He won. So he was right. The Judge Taylor was wrong. Okay, so he then sued him. He sued the judge, right? I love it. He sued the judge, and just to really be awesome, he's like, well, when you sue someone, you have to serve them with the lawsuit. That's the law. So he goes back to the judge's house, right? And then when he serves the judge, he said, let me read it here. In a loud voice, respondent called the judge, among other things, a corrupt judge, and yelled, "The pedicab case went to trial after you lost an appeal to me, and we won. So fuck you, Judge Timothy B. Taylor." So respondent continued to yell at Judge Taylor as he retreated from the house. Let's see, that was about the worst that it got. So I don't know. He got disbarred. Now, to me, it's like, okay, what do you think? Yelling, saying, "Fuck you, Judge Taylor, you screwed me over." Is that more threatening than these thousands of Facebook messages? Go die and fuck you. You know what I'm saying? Like, give me a break, dude. I don't know. I honestly can't figure it out. Why, the theory, what judges say though, is they say, well, it's different with a judge than with the singer, because it's like you could be trying to dissuade the judge, from how they're going to rule. And my theory is, well, so what? Like, why aren't we allowed to try to dissuade a judge how they're going to rule? But they're like, but if there's any sort of like hint of violence, even if it's so little, then, but nowhere does, because he said, hey, I was just exercising my free speech. I wasn't going to hurt him. I just wanted to vent my frustration, right? There was no, he got disbarred. They didn't make a jury prove his subjective element. So to me, I think if the court's going to pass this, I think Joe Samo should be able to write a letter to every Supreme Court judge saying, "F you, go die." What do you think? No? Okay. I won't do it. All right. Great work today, Stuff. All right. See you next week.